Hello and welcome to the Federal. For the last few years, a perverse form of justice was being dished out and served to the people under the disguise, as these things usually are, of swift and decisive action of justice against people accused of various crimes. Invariably, these accused would be from a religious minority, particularly the Muslims. What was this injustice? It was something that was dished out to the people under the name of bulldozer justice. Houses were razed, private properties were razed merely because somebody had been accused of a certain crime. And that crime could have been anything. There was no fixed description of those crimes. It started with Uttar Pradesh under Chief Minister Yogi Adityanath. Very soon after, various other BJP ruled states, their chief ministers began to emulate it. And it kind of became a fashion to bring in bulldozers, and people, from the ruling party, the BJP, began calling it bulldozer justice. Until one day, there were finally petitions moved in the Supreme Court seeking action against this kind of injustice, a curb and end to this injustice. Belatedly, but today the Supreme Court has finally given its judgment, a very strongly worded judgment, a very clear judgment that calls all such action, this bulldozer injustice, illegal, unconstitutional. It also lays down very clear guidelines of what is the right process to be followed, even if this bulldozer has to be rolled in to demolish a private property, a house of an accused, or as the Supreme Court judgment repeatedly mentions, even a convict. I have with me Anas Tanwir, an advocate in the Supreme Court, to break down this judgment, explain what it means, its significance, its implications, and what these guidelines are, which the Supreme Court has laid down today. Welcome, Anas.
Thank you,
How
Producer.
important, how important do you think this judgment is, and the basic uh, operational part of the judgment, if you could explain briefly?
This judgment, without any doubt, is historical. This is, and also unfortunate that it had to come to this. Most things, most part of the judgment is a reiteration of the existing laws and the legal principle. For example, the court talks about rule of law. The rule of law is for the state to maintain. The court talks about separation of power. That is also an old principle. Court talks about right to shelter. Again, an old principle. Why did the court had to be forced to reiterate this is a question that should be asked. When the state becomes the judiciary as well as executioner, then the rule of law fails. That is what was happening. Every single time there was an incident involving, and especially, and not only minorities, Muslims, but especially Muslims, there was a bulldozer. It became a symbol of election. It became a symbol of, say, supremacy of a particular kind of ideology. And today, the Supreme Court has put a brake on this bulldozer. The judgment is not merely words or platitudes. The judgment has actionable claims. It has actionable, whatever is in there is to be implemented. And the court has not just left it to the state. It has said that you will implement it in 1 month. And if it is not implemented, one can file the contempt. And we will, in further discussion, we'll discuss, we'll go threadbare on this judgment. But this is particularly historical and also unfortunate that the court had to say all this.
Now, I'll briefly elaborate on a few points that the judgment makes, points which Anas has mentioned, uh, right now. The the court, while talking of the principle of rule of law, says that there is no scope for arbitrariness of officials. The essential purpose of the law is to prevent abuse of the law, and that prevention of this abuse of the law is integral to and necessary for democracy and good governance. On the issue of separation of powers, as in the powers of the judiciary to adjudicate on a case, and the powers of the center or of the party in power, of the executive. It has said that it is wholly impermissible for the executive to replace the judiciary in performing adjudicatory roles, penalizing people undergoing a trial with a punishment of demolition. Anas, when this whole bulldozer justice or sort of was
That is also a
coined,
very unfortunate term.
it's an unfortunate term, but and as I said, it should be something that should have always been referred to as bulldozer injustice. But
Injustice.
when this was peddled to the people as bulldozer justice, it it was almost showcased as a model of good governance, of swift and decisive action, of a very muscular government, which does not condone any kind of
Yeah.
criminality. So when the court today points out demolition as a case and says that talks of abuse of the law and uses terms like or phrases like prevention of the abuse of the law is integral to and necessary for democracy and good governance. How much of a embarrassment or an indictment is this uh, for the powers that be, for the executive?
This is very embarrassing. There is one thing that I'll just read out from the judgment opening lines. It says, okay, there's some problem with my phone here. But anyway, if the court very clearly said this, that it has become a symbol of injustice. The court doesn't mince words in this judgment. When the judgment starts with a Hindi poem from Pradeep, and it talks about having house, the court had gone into this. The court had said that it is a dream, it is not just a house, that property. It is someone's dream, someone's lifetime accumulation of lifetime wealth for a lot of people. So, for example, if I come from a middle class family, my father was in some service, we could get our first house only at the time of retirement, because it would require a collection of every salary, savings, and everything to get one house made. And it takes hardly 15 to 20 minutes to demolish a house. And this was not fair. The court has gone into the humanitarian aspect of it. When the court talks about right to shelter, it talks about this, that it is your fundamental right. It is part of Article 21, right to life. This is your fundamental right, and a fundamental right cannot be taken, right to life cannot be taken away except for the procedure established by law. The procedure was established. What court, the guidelines is, most of the it is a reiteration of the existing laws that the government, which is duty bound to implement that law, was not implementing. The court also talks about singling out certain houses. That if in an area there is an encroachment, you single out just one house, the state cannot be arbitrary. The state cannot be prejudiced against a certain community, in this case Muslims. So this The court has actually set the clock back and set the clock right, showed them the right path to follow, and has also given the people for whom the government must work and for whom the democracy exists and for whom the court serves. It's given them the right to come back to court if something like this or something unfortunate like this happens. And if you ask me, the most important part of this judgment is the personal responsibility of the officials. That restitution, the court says that if a property is illegally demolished, then the officer concerned who ordered that demolition will not only restitute that property from his own expenses, from his own money, but will also pay damages. And in
That's
my
right.
experience, whenever there has been a personal liability of officers, the injustice stops immediately. They do what they have to do under the veil of state, because state is mighty, state is strong. But once that veil is pierced and you look at officers personally, it is then these injustices stop.
Right. So, the judgment in very, very clear terms, very clear language, spells out, and it uses Article 142, it uses its special powers under that article to lay down very, very clear guidelines on what is the procedure to be followed, even if a demolition is to be carried out.
Right.
And this is, of course, uh, what you've mentioned. It makes a lot of ground for establishing institutional accountability.
Yes.
And it also talks about erring officials. What are the penalties? What are the punishments if an official is to, not follow the protocol
Right.
laid down? If you could explain these guidelines that the court has laid down today.
Right. The most important, it begins with notice. It says that no demolition should be carried out without a prior show cause notice, returnable either in accordance with the time provided by the local municipal laws or within 15 days' time from the date of service of such notice, whichever is later. So, minimum 15 days is given. What used to happen is that whenever we have challenged any demolition, calling it illegal, the state comes and says, no, 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 we served the notice, this was an encroachment. They may say a different thing in media. They may reflex their muscles, be chauvinistic about it. But in court, they always held this line that we served notice, these were encroachment, that is why we demolished them. Now, in our case only, let's take our case. I was representing one Ganesh Gupta, whose shop was demolished during the Jahangirpuri demolition that happened immediately in aftermath of law and order disturbance, riots in Jahangirpuri. Now, in this case, the state had annexed with their reply a notice saying that we have served notice upon them. That notice did not even have the same address as my shop, nor my name, nor the name of my wife. So now the court has made a mechanism. There was also the case where there were allegations that the notices were never received. They were never served, but they have shown that they have sent a notice. They used to backdate the notice. So now that backdating will also stop, because not just the 15 days time for the notice, that notice will also mention why demolition is necessary. Because before demolition, let's say for example, I have a balcony, or I have encroached on the road a little bit for my garage, for my parking space. You cannot demolish my house for that. If there is an encroachment, you will give me a notice, and I will take measures to remove that encroachment myself. I will also get an opportunity to put my case before you why it is not an encroachment. And when I put those cases before you, the minute of meeting will also be recorded. The notice will be sent to me if my house is to be demolished. The notice will be pasted on the wall of the property that is sought to be demolished, And most importantly, the notice will be sent to the district magistrate as well, so that there is no
And all of
backdating.
this has to be done on the same date.
Yes, and through
It
email.
cannot be done, if I'm not mistaken, it
Right,
cannot be
right. It has to
done
be done in the
in a
same day so
manner
that there's.
that allows backdating, right?
I will read what it says.
Yeah,
To prevent any allegation of backdating, we direct that as soon as the above show cause notice is duly served, intimation thereof shall be sent to the office of collector slash district magistrate of the district digitally by email, and an auto-generated reply acknowledging receipt of the mail should also be issued from the office of the collector. The collector shall designate a nodal officer and also assign an email address and communicate the same to all the municipal and other authorities in charge of building regulations and demolition within 1 month from today. So there cannot be a
right.
backdating now. It will be very difficult for them. Okay, there used to be a register that they used to maintain, and obviously it's a manual register. You can play around with it. It is in your possession. Now it can't be done. The notice, as I said, will also have all the required details. Why demolition? Why not compounding? Why not fine? And I will have a right to put my case. The minutes of meeting will also go to the district magistrate. And if it comes to that the demolition becomes necessary, after all this, there is an adjudication of encroachment. Okay, there has to be an adjudication that this property is an encroachment. In that case, the state will have to mention the name of all the police officials as well as civic officials who are present on the duty there, who are conducting the demolition. And if an order of illegal demolition has been passed, that errant officer will be brought to book. He will be punished, and he will have the duty to restitute that property. This is landmark.
Right. So, Anas, one more point of clarification. When
Hmm.
the judgment talks about appointing a nodal officer to adjudicate on the need for a demolition or the
Right.
merits of the notice for demolition, to my understanding, the judgment also says that even after a final order is served,
Hmm.
that final order within 15 days can be appealed against.
Yes.
And
So
that
this was.
final order, if I'm not wrong, also needs to mention why the demolition has been allowed, and if at all not, demolition has to be beyond the encroached area. If at all the structure has to be demolished because it is in such a fashion that the encroached area uh, cannot be removed without removing the full structure, then reasons have to be cited.
Yes.
That is my understanding.
Yes, you're
So,
absolutely
uh,
right.
so if you could just elaborate on this process of the appeal, and what is the procedure that has been laid down?
Okay, so first of all, let me just mention this. All the demolitions that have happened, first of all, we are not against the demolitions per se. There's sometimes requirement of legal demolitions as well. There are encroachments on the road. We obviously don't want our roads to be encroached. But we were on the point that there should be that the rule of law should be followed. The rule of law says let's for example take the Municipal Corporation of Delhi Act. Okay, Delhi Municipal Corporation Act. Almost all the state laws are similar on this aspect with little differences. It says that first a notice will be served if you have identified it like this state has identified an encroachment. You will serve the notice upon the owner or the resident. They will have they will be given a particular time period to reply to that notice. There are municipal tribunals, there are court where you can approach and get a stay against your demolition. If that court says, no, yeah, this demolition has to happen, this is what the existing law was, then I have the power to appeal that. I will be given time to appeal that. There is a certain period that is given to file appeal also and seek stay. What was happening is that, for example, yesterday something has happened, today there will be demolition. There is no
Right.
opportunity of hearing. In my case, matter of fact, we have made this averment also that Ganesh Gupta tried to show the documents, the tax receipts, the permissions, and everything to the official who were present there. They did not even look at that, leave alone giving an opportunity of hearing. So now the court says that there will be an appellate, there can be appeal also. You have to give a reasoned order why only demolition. From notice to the order, everywhere you have to mention all the particulars and give all the reasons.
Right. Now, I, let's come to this very important, very significant aspect of the restitution.
Hmm.
And if I can take the liberty of, broadening that recommendation a little, or maybe, reading a bit more into it, the court says that if there is an official who has violated the procedure, the official can be held to account, will be made to pay for restitution, and out of his personal pocket, at his personal cost, plus the damages. Now that, of course, is something that needs to be hailed. My point here, Anas, is we've seen this time and time again, that officials are told to do what they do uh, by the political brass.
Right.
A minister, or perhaps the chief minister in certain cases.
In Jagirpuri case, there was a letter from the mayor.
Yeah, who sanction these kind of things, and or there may not be a written order at all. You may
Right.
receive, an official may receive a call from a political master, the minister concerned, the mayor, the chief minister, the chairman of a board, n number of people, the local MLA, and be told that I don't care, go and demolish the thing. It's very difficult for the official to then establish that what he did, he was forced to do because he had no option. Now, I'm not defending the action of the official, but in certain cases, could this also be create a scenario where you get the small fry, the small fish? It may, of course, be a deterrent, because there may be officials who will say, I'm not going to do this because it's going to cost me a lot, and I will follow the letter of the law. But there may be officials overeager to protect the political masters. There may be officials who will not be able to stand up to their political masters, and in the court of law may not be able to prove what has happened. Uh, how do you see this provision of the judgment in light of such a possibility?
Right. See, an officer, whenever is appointed, he or she is appointed, they take an oath to serve the constitution, to serve the law, to serve the people, not their political masters. I understand what is the reality, what is the truth, but now this gives those officers also a, a place to stand on. Gives them strength. See, I can't do this because I will lose my job. And even after if they are forced, they can always seek for a written order. Ask the political masters for a written order. Let them be responsible. If you want to absolve your responsibility, you'll have to put the responsibility on someone else. The person who is ordering you, you will inform them that I cannot do that. And even if you are doing this under whatever compulsion, then you are betraying your oath. So there cannot be a sympathy with an officer like that. I was narrated this story by my guru, Mr. Sanjay Hegde. He said that a young chief minister, when came to power, and there were a lot of disturbance in his capital. I will not name the chief minister. It's
Right.
pehle ki baatein hain. But as chief minister in a southern state, rather, he called up his DGP and said, I don't want these riots. They don't help me. And if that happened, I will hold you personally responsible. There were no riots after that. So wherever, and we incorporated this personal responsibility when we advocated for the lynching guidelines also. The Supreme Court had
Right.
passed those guidelines in Poonawalla judgment in 2017. And all these things, when there is a personal duty of a police officer or of a magistrate or a district magistrate or a collector, when it comes to their job, they will do everything to prevent illegality from happening. The public only has as much power that the state gives. or the judiciary gives. The judiciary today has given power to people to come back to court if any illegal demolition happens, and make and ensure that they get the restitution of their property and the damages from the errant officer who is on the ground or who has passed the order.
Okay. So we're towards the end of our discussion, but I have two quick questions
Right.
to ask. One, this judgment has taken its own time to come. Of course, a judgment that needs to be welcomed. In between, we also had judges who sat on this because they were perhaps worried about their legacy. But you know, in the process of this long time from when this bulldozer injustice began to now, countless number of homes have been raised, private properties have been raised. Does this judgment do anything to help those people? Can they cite this judgment and move court now and say that, look, this is what had happened to in our case, and we need to be paid damages? Is that a possibility, or will this only be prospective?
See, I am yet to read in detail this judgment, to be honest. Yeah, I was there
Okay.
for the pronouncement, but it's been a long day. But I'll tell you something that for the claim for compensation, there's already a provision in law. There's nothing stopping people from exercising that. People just don't know about it. Perhaps, matter of fact, my petition was for compensation. Originally, it was for
Right.
compensation. The court has ruled on the larger aspect, on the larger question. Has not gone into the individual cases. The court may get an opportunity to do that in future. I'm hoping that at least this part should have a retrospective applicability. But then also the question comes, I mean, uh, the question is this simply, that you have the power to go to claims commissioner. You can always seek, and this will give you a basis to show that the demolition was illegal, that the notice was not served upon us. There are provisions in that in existing law. So even beyond this judgment, you have that power. You can claim for compensation, not the compensation from the errant officials, but from the state itself. So there is nothing stopping people today also from going from seeking compensation. What happens is, once their houses are demolished, most of these people are poor people. Either they are
Right.
poor, they are Muslims, they don't have the strength to fight, they are scared to fight. And this is where the State Legal Services Committee should come into action, where different organizations should come into action and help these people. Because the right is there, the provision is already there. You can even today claim compensation for wrongful demolition. There's nothing stopping. This judgment is not coming in between at all.
Right. So, final question. With this judgment, of course, very strong guidelines, very clear guidelines, but we've also seen very clear, very strong guidelines being laid out in cases, in fact, in cases in which you were, one of the lawyers, lynching, hate speech, and those issues have, of course, continued. The state's responsibility has very often been brought into question, but no actions been taken. How hopeful are you that this would be different?
Look, if we don't have hope, then what are we fighting for? So I'm really, really hopeful. And I have seen, I started an organization because the lynching guidelines were being implemented out of anger from that. So sometimes it then becomes, if the state fails, and let us call it the failure of a state. The state may be hateful, but let's call it their failure. The prime duty of the state is to maintain rule of law. They exist because of rule of law. It is their duty. If they fail in implementing, then it is upon us, on lawyers and citizens, to come to court, to knock the doors of the court, to make them, to force the state to act in accordance with law. This is how
Right.
unfortunately, the nation will work. In ideal situation, there is a judgment, but in ideal situation, there should not have been bulldozer injustice. But we are not living in that, and that is an unfortunate reality. But now that we have a judgment, and the judgment is a slap on all those who celebrated this perversity, this hateful conduct from the state, not from a mob, not from people, but from the state itself. This is a tight slap on their face. This is a tight slap on the leaders, on the politicians who rode bulldozers, and this is a tight slap on the media also, that in Jahangirpuri, a particular anchor of a renowned news channel rode the bulldozer and was very happy about it. It is a tight slap on her face as well.
Well, on that note, and in the hope that these guidelines, this judgment will put an end to this injustice, uh, we conclude this discussion, and we hope that the officials concerned, the governments in the state, the government at the center, will follow this Supreme Court judgment and the guidelines laid under it. Thank
Same
you.
hopes, and if they don't follow, we will hopefully fight again to make them follow the judgment.
Right. Thank you. Thank you.
Thank you so much, Puneet sir.